Hi everyone. Today's unit that we'll be doing is public law, and my name is Shazia Khan. Today, the learning outcome we'll be looking at is learning outcome 5, which is to understand the nature of and procedures for judicial review. In the last session, we looked at learning outcome 4, which was to understand the composition and operation of legislature and the UK government. We started off with looking at what a bill is in learning outcome 4, what statute is, and we looked at the passage of an act of parliament. So how the stages came about in regards to making a bill into an act of parliament and the procedure that it goes through. Both we looked at the procedure in the House of Commons, and we looked at the procedure in the House of Lords. So things like we went through the first reading, second reading, we looked at the committee stage, we looked at the report stage, and the third reading, both in the House of Commons and the House of Lords. And then we looked at any sort of consideration for amendments, and then we looked at the final stage, which was the royal assent. And we looked at the procedure and went through what happens at each stage and why it's so important that they are considerations of amendments, and when everything starts coming into place, when are the important bits, things like the committee stage and where amendments are made, the report stage and the second reading. We also then went on to look at the structure of devolved powers in the UK. So we looked at what devolution was, why we have it. We looked at the legislature and the executive in regards to the UK Parliament, Scottish Parliament, National Assembly and Northern Ireland Assembly. We looked at how devolution works, and we looked at the different political parties in administration. We also looked at where powers, which powers are reserved and which are devolved within the different policy areas such as health and social, education, transport and taxation. So different areas we looked at. We looked at the powers of the Scottish Parliament's Welsh Assembly and the Executive Committee of Northern Ireland, and we looked at the Scottish Parliament at Holyrood, the Scotland Act 1998, and the Scotland Act 2012. We then looked at the issues, what we mentioned earlier, the devolved or reserved. So what's the difference between both and what is included? So, for example, in devolved matters, it included things like agriculture, forestry and fisheries, education and training, environment, health and social services, housing, law and order, local government, sport and the arts, tourism and economic development, and many aspects of transport. Then we looked at reserve matters, which included benefits and social security, immigration, defence, foreign policy, employment, broadcasting, trade and industry, consumer rights, data protection, etc. We then went on to look at both the Scotland Act 1998 and the Scotland Act 2012, and why the acts were passed. We looked at devolution settlement in Wales with the Government of Wales Act 2006. Then we looked at what is dissolved. So we look at the Parliamentary and Assembly primary legislation affecting Wales, the Wales Act 2014 and the Wales Act 2017 with reference to changes. We also looked at the Northern Ireland Assembly Act 1998. We looked at transferred matters in regards to the Northern Ireland Assembly, things like health and social services, agriculture, etc. Reserved matters again. We then looked at the parliamentary privilege and when it was published in 1999 and the elements of that, why there was a need for parliamentary privilege in regards to the MP expenses scandal. We also looked at the Joint Committee on Parliamentary Privilege, and then we went on to look at the advantages and disadvantages of first past the post system and plurality in the UK. And we looked at the first past the post system and what the system does, and the alternative voting system in regards to the procedure and how things are structured. We looked at advantages and disadvantages of the first past the post system and why it is used in the UK. Now we'll be going on to learning outcome 5, which is to understand the nature of and procedures for judicial review. So the key terminology, what is judiciary? A judiciary is a system of courts of law. The judges of these courts, branch of government in which judicial power is vested. What is the role of the judiciary? So the judiciary is the branch of government which administers justice according to the law. The court apply the law and settle disputes and punish lawbreakers according to the law. Our judicial system is a key aspect of democratic way of life. It upholds peace, order, and government and good government in the UK. What is judicial review? So judicial review is a particularly important aspect of the constitutional settlement in the UK. It is a process, a court case where a judge or judges decide whether a public body has behaved lawfully or not. (5.1) Appraise the scope and limitations of judicial review. So just a little bit on, again, on the limitations of judicial review is judicial review is a type of legal case where a judge or judges review the lawfulness of a decision or action made by a public authority. Public authorities include people like local councils, government departments, ministers, police forces, the government ministers, the council, and regulators and health authorities. So there's a variety of different people that fall within the definition of public body. So 5.1, appraise the scope and limitations of judicial review. Where a public body makes a decision or acts unlawfully, there are a number of ways that those affected can challenge the behaviour or decision. These include complaining to using public body's complaints procedure or ombudsman, exercising rights of appeal to a tribunal if such rights exist in relation to a particular decision to be challenged, such as welfare benefits, asking a public body to review its decision through a process called judicial review. It is necessary to bring a judicial review application promptly and in an event not later than 3 months of the decision, action or inaction you want to challenge. Some types of judicial review must be brought sooner, within 6 weeks, for planning decisions. Judicial review in the UK in English law. What is judicial review and why is it important? Second, due to its powers, judicial review it plays an important role in ensuring that each branch of government recognise the limits of their own power. Third, it protects civil rights and liberties by striking down laws that violate the Constitution. Judicial review is a particularly important aspect of the constitutional settlement in the UK. It is a process, a court case where a judge or judges decide whether a public body, as we mentioned earlier, has behaved lawfully. It offers a route to justice for those adversely affected by public body decision-making, and it performs an essential task in that it allows the courts and judiciary oversight of government decision-making, be that central or local government or parts of the state that implement government policy, including the NHS or the police. And there's a handout on Moodle, which is labelled 5.1, and it's the introduction to judicial review, so that you need to understand more around the area of judicial review, and there's more detail on that. 5.2, evaluate the procedural steps of judicial review. So judicial review, as we mentioned, is referred to as JR, is the process of challenging the lawfulness of decisions of public authorities usually local or central government. The courts have a supervisory role, making sure the decision maker acts lawfully. It is important to understand that a JR is not a rerun on the merits of the decision, but a challenge to the lawfulness of the decision that was made. If a JR claim is successful, then the usual result is that the decision is quashed or nullified. In turn, this usually means that the decision has to be taken again. In planning cases, this means that the application will be reconsidered, having rectified any defects found, for example, the EIA or other information required. This can result in exactly the same decision being taken, so victories in JR can be Pyrrhic. Steps in the judicial review system. So firstly, in the defendant exercising a public function, does the claimant have sufficient interest? If there's a decision which may be reviewed, are there grounds for judicial review? So the grounds would be, has a body acted illegally? Has a body acted unreasonably? Has there been procedural impropriety? And has there been a breach of the Human Rights Act? If that is yes, is there an alternative remedy? Are any of the remedies available in judicial review appropriate, and can a claim be made prompt within 3 months or the relevant decision? On the other side, we've got a handout which looks at judicial review procedural steps. Judicial review requires permission from the court. One of the most important requirements is that the application for permission is made within the short time during which claims are allowed. So, they don't like to keep processes in long, a lengthy process. They want everything to be done quite quickly. Time limits and pre-action protocol, PAP. Judicial review requires permission from the court, as I've just mentioned. One of the most important requirements is that application for permission for judicial review is made within the time limit by the courts. Pre-action protocol. The first step in judicial review is to write a formal letter to the proposed defendant, setting out your proposed claim and what you are seeking. This is known as a pre-action protocol or PAP letter. This is known as a pre-action protocol or PAP letter. Normally, a response is expected within 14 days in cases challenging a grant of planning permission, 6-week limit to issue a claim. Does not leave much time for pre-action correspondence, although you must try to complete it if possible. The next one is the permission stage. If the response to the PAP is unsatisfactory, you may lodge a judicial review claim in the planning court or administrative court branches of the High Court handling JR cases. The first stage is to apply for permission. The test for obtaining permission to proceed is that you have an arguable case. The court will weed out cases where it cannot see an arguable error of law. Another test at the permission stage that can be important, but is usually not a problem, is that you have a standing. So in effect, a genuine interest in bringing the case rather than being a mere busybody. In practice, problems arise when clients approach us at the 11th hour within the 6-week limit, and we have a file proceedings without having much time to digest the papers and consider the merits of the claim, either ourselves or with counsel, and then formulate it properly. In all cases, judicial review or statutory appeal, it is best to avoid problems by taking advice as soon as possible after the decision you may wish to challenge is made. The process for applying for permission. In principle, this is simple. You complete a short claim form setting out the facts, your grounds, why you consider the decision unlawful, and certain other details. You provide documents explaining the background to the case and relevant legal provisions, and you lodge these with the administrative court with a modest fee. In practice, however, this permission stage can involve a lot of work, considering documents, chronology, and analysing and what legal grounds you have or don't have to apply for JR. Once issued, you are served with the defendant and other interested party, for example, holder of the planning permission you seek to challenge with papers. They can, and almost always do, submit summary grounds of defence to explain why it's unarguable and permission should not be granted. In practice, there is no provision for this in the rules of the procedure. You, the claimant, then have a short window of opportunity to reply to those defences. The court then sends papers to a judge for a decision on paper. If the permission is refused, you can review the decision to be heard in an open court. The other parties may or may not attend. The substantive stage. If permission is granted, the claim proper can proceed. How complex this turns out to be depends on the circumstances. In principle, one awaits evidence from the defendant and interested party. In other experience, interested parties tend to put in a large amounts of evidence in an effort to show how much care was, they say, in fact, given to making the decision in question and how much money they would lose if the decision was quashed. These factors should not sway a court if the decision has in fact been unlawfully, but inevitably they often do. Therefore, it is necessary to be prepared to undermine this sort of evidence. Sometimes, particularly in urgent cases or in straightforward cases that should not take long to argue, or in cases that are so complex that it is difficult for a judge to quickly determine agreeability. A judge may order that both the permission stage and substantive stage be heard at the same time. A rolled-up hearing. This is more likely to happen where one party has made an application for the case to be expedited, which means heard sooner. A rolled-up hearing has the advantage of getting the matter dealt with quickly, and in practice is cheaper than the more drawn-out two-stage procedure. However, it can have cost disadvantages. The culmination of the second stage, which is the final stage, will, however, usually take place a few months after the receipt of evidence from the other parties and the claimant filing any further evidence. A few weeks before the date fixed, counsel for both sides will submit skeleton arguments, summaries of the respective legal cases, and the judge pre-read these and essential parts of the paper. If this is done, the hearing itself can proceed quite rapidly. Judicial reviews seldom more than 3 days, and many in our experience are over 1 day. The costs. Although going to court is certainly expensive, the relative speediness of judicial review process means that costs are not the telephone numbers one reads about in the papers for libel cases and so forth, where the case goes on for a long time, usually due to the need for witnesses appearing in person. In judicial review, evidence is almost always given on paper. Rules about costs are complicated. However, there are protections in place. However, they are becoming more favourable for claimants in environmental cases that are generally less of a practical and procedural obstacle. However, the general rule remains that the losers pays the winner's cost. But usually one can obtain protection from the risk of paying opponents' costs beyond a specific level. If you are considering bringing a judicial review or statutory challenge, you would need further advice in regards to costings. Sometimes the amounts of costs that have to be paid is assessed on the spot which is summary assessment, or it may be detailed argument before specialist costs judge. The judgment. The judge may deliver judgment there and then, ex tempore or orally. Shortly afterwards, or it may be handed down in writing later. Handed down judgments are more satisfactory as they are usually better thought through, and one also does not have to expend time and cost for the time it takes to attend delivery of an oral judgment. With oral judgments, a transcript can be obtained but may have to be paid for. After judgment is given, there is usually argument about who pays the cost and whether the permission should be given to the appeal the decision. If judges usually refuse permission to appeal, and one has to apply to the Court of Appeal directly for permission. And for details of appeals to the Court of Appeal in regards to applying for the initial stage of an appeal. 5.3, distinguish between substantive breaches and procedural impropriety. So a contract may be broken if either you or your employer does not follow a term in the contract. This is known as a breach of a contract. For example, if your employer doesn't pay you in lieu of notice, which you are entitled to under the contract, this would be a breach of contract. What is substantive breach? A substantive breach is when the tenant breaks one of the obligations set out in Section 21 of the Residential Tenancy Act, or the landlord fails to meet the minimum housing standards. A substantive breach can also occur when series of breaches are committed, the total effect of which is substantial. Then we've got what is meant by procedural impropriety. And this is a failure on the part of public authority to act in accordance with the requirements of procedural fairness and in compliance with the common law rules of natural justice. And this actually means that the authority, as we've mentioned, not complied with the relevant regulations. For example, the PCN or other document did not give the required information. The authority did not respond to your challenge or responded to too late. And there are different elements of procedural impropriety. The first is failure to comply with procedural requirements set out in statute. Secondly, there's a broader heading of failing to act fairly, the core of which are the rules of natural justice. In what case was procedural impropriety defined? The Lord Diplock in GCHQ said that procedural ground, this is because aims to review the procedure of a decision maker rather than their actual decision. When does a procedural impropriety claim arise? From either failure to observe, as we mentioned, procedural rules set by statute, as in the Aylesbury mushroom case, but minor infractions may not render a decision void, as in the case of Heron, or if the common law rules of natural justice have been not been adhered to, so which is a duty of fairness. What are the two aspects of duty of fairness? The right to be heard and the rule against bias. To what type of decision does the right to be heard apply? And both administrative and judicial, but administrative ones attract a lower level of fairness, as in the popular case of Ridge and Baldwin. And the Ridge and Baldwin case in 1964, the key point identified in this case was that the doctrine of natural justice and the right to a fair hearing is not limited only to executive decisions made in a quasi-judicial setting. The facts in this case was a watch committee could exercise its powers under the section 191 subsection 4 of the Municipal Corporations Act 1882 to dismiss Chief Constable on the grounds of negligence or unfitness. The appellant, a Chief Constable of Borough Police Force, was arrested and charged with the conspiracy to obstruct the course of justice. He was acquitted of the charge, yet the sentencing judge had commented adversely on his character and his suitability for the post. The Watch Committee then dismissed the appellant from his office by exercising the power conferred to them by the 1882 Act without informing him of the charges against him and without giving him the opportunity to be present in his case. The Court of Appeal held that the principles of natural justice did not apply as the decision was administrative in nature and the principles only applied to decisions of judicial, quasi-judicial nature. The issue that was identified in this case was that had there been a breach of the doctrine of natural justice in the manner by which the Watch Committee had dismissed the Chief Constable, it was held that the appeal was allowed. There had been a breach of natural justice in this instance, as the appellant should have been informed of the charges made against him and should have been given the opportunity to be heard. Lord Reed in this case identified, although there exists no clear definition of the principle of natural justice, it cannot be said for this reason that therefore it does not exist. There's an unbroken line of authority to the effect that an officer cannot lawfully be dismissed without first telling him what is alleged against him and hearing his defence of explanation. As such, the power of dismissal under the 1882 Act cannot be lawfully exercised until the appellant had been properly informed of the charges against him and given the opportunity to make representations on his own behalf. Since the decision to dismiss the appellant was made without regard to the principles of natural justice, they identified that it was therefore void. The case of Ridge and Baldwin, it marked the beginnings of the change in the landscape of English judicial review, as it paved the way towards a more contextual approach as to what constitutes procedural fairness. As Thomas Poole recognised this change in the nature of judicial review, which was also marked by important judgments in the case of Padfield and Annis Minnick, had a lot to do with ensuring that abuses of public power were curtailed and the rule of law maintained, rather than placing an emphasis on protecting the individual from such misuse of power. And that was identified in the book by T. Poole, The Reformation of English Administrative Law, 2019. What are the exceptions to the right of heard? And the case in regards to that is the GCHQ in to do with national security. Emergency situations was to do with the Pegasus case. Rationing of resources, Cambridgeshire AHXB, waived right to fairness, Lloyd and McMahon. Has the level of fairness decided upon? Circumstantially be case if it's a flexible concept, as in Lloyd, look at how it affects individuals, the character of the body, the statutory policy framework. The case of Durayapi and Fernando's, there were three factors that were considered. Firstly, the nature of the office, the circumstantial seriousness, as in the case of Ridge and Baldwin, and the sanction higher of the definition Cooper and Wandsworth. How do license applications impact upon the establishing the duty? The case of Liverpool taxis, those granting must act judicially, weighing up arguments. McKinsey and Onslow distinguish between application and forfeiture cases. The latter needs a higher DOF because people have a legitimate expectation to be explained why they lose. R and Gaming Case Board. And then after the level of fairness has been decided, the content of fairness must then be ascertained. What is required in all of the circumstances? What does this involve? So the right to notice and information, polemists must be given enough time to prepare. The right to make representations, the right to call, cross-examine witness. St. German depends on the nature of body decision concerned prison riot, the right to legal representation, and the right to have reasons explained. Concerning the right to make representations, whether they are oral or written, to be determined. In the case of Aaron Army Board ex parte Anderson, the criteria for deciding if oral, so look at subject matter, nature of the case, decision, and substantive factual issues. For example, in Aaron, Smith and West, no hearing as already in prison. It was noted that if facts are disputed or the character of the individual is important, then always oral. The case of Wiseman and Bowman, so long as the whole process is fair. The right to have legal representation is governed by which cases. The case of Horn, there's no general right to legal representation, but generally it should be exercised in legal favour, as in the case of Pet and Greyhound. Ex-tarrant, the more vulnerable the claimant, the more likely they are to get it. M5.1 appraise the boundaries between private and public law. Public law refers to the relationship between individuals and the government. In the UK, public law is made up of constitutional, administrative law, tax law, and criminal law. Why is public law important? Public law is important because of the unequal relationship between the government and the public. What is the difference between private law and public law? In general terms, private law involves interactions between private citizens, whereas public law involves interrelations between the state and the general population. Private law applies to any circumstances relating to the relationship between individuals in a legal system. Therefore, this type of law governs the relationship between individuals and other governments. This is also referred to as common law. What is public law? Public bodies such as central and local government have to obey the law. The type of law governing the conduct of public bodies is also known as public law. Public law principles mean that public bodies act lawfully, rationally, fairly, and compatibly with the human rights of those affected by their actions. Where public body acts unlawfully, there are a number of ways that those affected can challenge their behaviour or decision. These include complaining using public bodies, complaints procedures, or ombudsman, exercising rights of appeal to a tribunal if such rights exist in relation to a particular decision to be challenged, such as in welfare benefits cases, asking a public body to review its decision, and through a process called judicial review, as we explained earlier. Some other laws that fall under this public law umbrella are administrative law, constitutional laws, criminal laws, municipal laws, and international laws. As we explained, judicial review is a particularly important aspect of the constitutional settlement in the UK. It is a process, a court case where a judge or judges decide whether a public body has behaved lawfully. It performs an essential task in that it allows the courts and judiciary oversight over the government. The diagram shows the separation of powers model and the relationship between Parliament, the courts, and the judiciary. The constitutional model exists to prevent the abuse of power. For instance, if the executive implements a government policy that turns out to be unlawful, that the courts can, if a case is brought to them showing that the policy is unlawful, give a judgment holding the policy unlawful. So as you can see in the diagram, you've got the separation of powers, the executive, which is the government power to put law into action. Parliament is the power to make and change the law, so any amendments and the passing of a bill to become a law goes through Parliament, and the judiciary, the power to make judgments on law. What is private law? Private law applies to any circumstances relating to the relationships between individuals in a legal system. Therefore, this type of law governs the relationship between individuals and the governments. This is also referred to as common law. It includes the law of property and trust, family law, the law of contract, mercantile law, and the law of tort. Common examples of private law can be found in organisations and employment. For example, the rules of behaviour established by an employer. This can be the form of a day-to-day rules such as no smoking at headquarters, no creation of a hostile working environment, and the penalties for breaking these rules can range from an oral reprimand to being removed from the organisation. Smoking indoors is a classic example of public against private regulations. As a public law, smoking indoors is prohibited in the UK. However, groups of citizens join together to create a mutual agreement between property owners, which the government has no regulation over, covered by this private law. Those within this property, often a pub, are then allowed to smoke indoors. As we mentioned earlier, private law governs interactions between individuals, and the application before a court in the first instance be from one person against another. A common example is an application for contract with a child. The parent who seeks the contact would make an application to the court against the parent and the guardian with whom the child usually lives. In doing so, they are asking the court to order that contract takes place and the resident parent makes the child available for it. There are many examples of private law applications within family law proceedings, but the above one, which I've just mentioned, is the most common one. Other common private law applications include applications dealing with how much time a child should spend with each parent, application dealing with whom a child should live, applications dealing with specific issues such as the child name. So these are different private law examples for you. Subdivisions of private law. Private law is also referred to as civil law. Some subdivisions of private law are contract law, law of tort, property law, labour law, commercial law, corporation law, and competition law. The difference between public and private law. Public law is a regulation of the legal system itself rather than the regulation of individuals. For example, some might say that if the publication of sexually oriented material causes a public harm or violates a public standard of decency, then it may legally be regulated. The private law is whether the act or acts affect society as a whole or an issue between two or more people. Certain acts that are said to be offences against society may be considered sufficiently public in nature to be classified as a crime. Many property crimes involve the infliction of private harm. Such private offences may therefore be classified as torts as well as crimes. So we finished the session now on judicial review, which is learning outcome 5, which was to understand the nature of and procedures for judicial review. And we looked at the issue of judicial review, the stages that everyone needs to go through to make an application for judicial review. We also looked at the issue in regards to natural justice, the locus standi, so that person must have a sufficient interest with reference to cases, and an important case which is Ridge and Baldwin. And we also looked at the difference between private and public law and why that is so important in the UK. These are some of the references that we've used in reference to Learning Outcome 5, which is Law Teacher, Richard Buxton, Brainscape, Wikipedia, Public Law Project and RKB. So if you need to go onto them, this will link you to take you to the link. Thank you for attending today's session, and thank you for your patience. And the next session will be to do with the assignment discussion for public law. So thank you for attending today's session.